Right from the beginning, the courtroom atmosphere is formal and procedural. But this moment carries serious consequences for Ariana Evans. The judge starts by confirming her identity and the case number, which is the first step before examining whether the terms of probation were violated. Once that review begins, the situation can quickly move toward the possibility of jail time. The mention of the GPS monitoring device may seem minor, but in probation cases it's extremely important.
Are you Ariana Evans?
Yes, ma'am.
And this is 22-41163, and Ms. Evans is currently on probation for a lesser offense of terroristic threat against a public servant, a Class A misdemeanor, and previously in court entered pleas of true to counts 2, 3, 4, and 5. I received an updated pre-sentence report. Has everyone had an opportunity to review that report?
Yes, Your Honor. Yes, Your Honor, I have.
Are there any additions or corrections?
No, Your Honor. No, Your Honor.
I have something.
These devices are used to track whether someone is following the court's rules. If the battery was dead for 3 days, that immediately raises concerns. The court may see this as carelessness, or even as an attempt to avoid supervision. Now the situation takes an interesting turn. Most defendants do everything they can to remain on probation because the alternative is serving time in jail.
Yes, ma'am.
GPS device, I was just emailed by Friday, 5:43, that it's been dead, the battery's been dead for 3 days.
Okay.
It's not being tracked at this point.
Okay. Thank you, ma'am. Mr. Kimler?
Well, Your Honor, the recommendation obviously is not favorable to Ms. Evans. I mean, they do provide an option that if the court does.
But here, the discussion suggests that Evans might actually prefer serving the time just to bring the case to an end. A choice like that can strongly affect how a judge interprets the situation, and suddenly, the earlier deal disappears. The 60-day option likely came from a prior agreement with prosecutors.
Maintaining her own probation.
Well, she doesn't want that.
Sir?
She doesn't want that, right? I mean, it says right here she just wants to do her time so she can move on with her life and put the case behind her.
Is that accurate?
Yeah, but I mean, if I like get the chance to like get reinstated, I'll do it too.
Which Steve as far as? What do you want?
If I can do the 60 days that they offer me and be off probation.
Well, 60 days is off the table. So that's what the state offered, I think, before. Y'all are unagreed. It's up to me to sentence you to.
But once negotiations fall apart and the decision returns fully to the judge, the range of possible punishment opens up again, potentially up to the full 180 days allowed for a Class A misdemeanor. At this point, the defense attorney changes strategy and raises mental health issues.
Yes,
So-
okay, so
What-
I'll have to be reinstated.
Okay,
It is a misdemeanor, you know, as a.
I understand. Go ahead.
And obviously, the easy way for her to address this situation is to take the revocation and take jail time on it. However, the defendant's version does indicate some mental health issues. And obviously, probation is a system designed to try to.
This approach can work in different ways. On one hand, it can support the idea that treatment might be more appropriate than punishment. On the other hand, if the judge believes the defendant has already ignored previous treatment opportunities, it could strengthen the argument that probation has not been effective.
Out of the actual criminal justice system in the future and avoid incarceration. So just looking at this, since it is just a misdemeanor, that I would suggest, just in her interest, and perhaps in the interest of the community, that she be continued, follow the maybe the recommendation you adjudicate with 30 days up front, or no upfront time, but the mental health component be addressed with Ms. Evans to see if she can make progress with her so-called incorrigible attitude, which I think under the DSM may be diagnosed as an antisocial personality disorder, whatever her issues are from the mental health standpoint.
Did you see that somewhere, or did you just make that up?
Well, I think that if they're saying she's incorrigible, I mean, obviously I'm not a mental health expert.
Okay, I just didn't know, I didn't see anything where she was diagnosed.
She hasn't been diagnosed with that.
Okay.
There's probably some issues there with
Okay,
obviously things that can be dealt with. through therapy.
Judge, I think incorrigible and defiant means she doesn't want to do probation, doesn't like people telling her what she can and can't do. I'd ask that we revoke her.
So, Ms. Evans, I mean, you were given, number one, you were given a great opportunity because you had a felony and they reduced it to a misdemeanor and put you on probation for 2 years. It looks like they gave you all types of help through JCDI, and you failed to complete your groups, didn't obtain a sponsor, you were testing positive, you were ordered to the Franklin North so that you could get some more intense help. You did okay in that, and then you got out and started struggling again. You were also ordered to go to Spindletop for mental health treatment so that you could get the help that Mr. Kimler is saying that you might need. And looks like they say you attempted to circumvent the requirements to obtain a sponsor. Your sister pretended to be your sponsor. You were placed on zero tolerance in JCDI. You tested positive for alcohol. You left the state without permission. I mean, all right. I'm going to find that you entered your pleas of true to counts 2, 3, 4, and 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the Class A misdemeanor of terroristic threat against a public servant. I'm going to sentence you to a term of 180 days in the Jefferson County Jail. You will receive credit on that sentence for any time that you were previously in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was not an agreement. You do have some rights to appeal. Y'all need to sign that real quick, please, Mr. Kimler, and give her that bottom copy. And he'll give you that copy of that, and then you can go with the bailiff.
Thank you, Your Honor.
Thank you. Thank you, ma'am.
Can I get my phone on my system?
Talk to the bailiff. Just talk to the bailiff.
I need to.